And our final topic in formation of contracts for today is whether the statute of frauds will bar enforcement. And this is one example of many exceptions where a contract will not be enforceable even though offer acceptance and consideration or an alternative is met. So we first look at whether a contract is covered by the statute of frauds, whether it falls in a classification. Then we look if there is an exception under that or multiple classifications, and then whether there is satisfaction if there is not an exception. We look at the restatement to define what are the categories covered. It includes 5 common law categories. But by the way, look at your jurisdiction because there will need to be an actual statute, right, in place in your jurisdiction for that to be enforceable. And so this is the way that it's structured in the restatement, and you can see here the provisions, but it may be more helpful to remember MYLEGS. And MYLEGS stands for marriage, the 1-year provision, contracts for sales of land, contracts where someone is going to be an executor administrator who's going to pay personally for the decedent's estate, goods sold for more than $500 or equal to $500, and suretyship where one is going to pay for the debts of another. So we have a couple exceptions to those. One applies to land and maybe to marriage. That's section 129 when there is part performance, and that's from section 129 of the restatement. A contract for the transfer of an interest in land may be specifically enforced, notwithstanding a lack of signed writing, if it is established that the party seeking enforcement in reasonable reliance has changed his position, has that change in position such that injustice can be avoided only by specific enforcement. And as you can tell by that, justice requires, we're in sort of an equitable kind of category, and we also have the equitable doctrine of estoppel, promissory estoppel, found in section 139. It mirrors, by the way, what we find earlier in the restatement for promissory estoppel, and so promissory estoppel can be both a reason to enforce a contract despite not having consideration, and to enforce a contract despite not having a signed writing. We saw that exception play out in the case of McIntosh v. Murphy. In this case, a gentleman was enticed to go to Hawaii in order to work for a car dealership. He thought he had a multi-year contract. And so a multi-year contract, a contract to work for several years, would fall into the statute of frauds for the 1-year provision. But there was no signed writing. So is our friend out of luck? Well, it turned out in this case he was not out of luck because the court found that promissory estoppel provided a valid exception because he had changed his position in reliance. So there was a promise made. I promised to the court found that there was a promise for a 2-year contract. That seems to be important. That promise was actually made, just wasn't written down. And would a person leave their job and move to Hawaii for a 2-year contract? Yeah, that's reasonable. Did that person actually leave their job and move to Hawaii? Yes, there was actual reliance. And the court here finds that justice requires enforcement. This is actually the unusual case. We saw another case that very similar facts, another contract for long-term employment. Stearns versus Emory Waterhouse came out the opposite way and found that justice would not require enforcement of an oral contract for services for years because that is exactly what the legislature was trying to avoid. Other exceptions pertain to the statute of frauds. So if the parties are merchants and one sends a confirmation to each other, if the goods are specially manufactured, if one party admits that there was a contract, or if the party either accepts the delivery of the goods or accepts payment of the goods, the contract will be enforceable despite not having a signed writing for a sale of goods. Even if we don't have an exception, we can still enforce a contract under the statute of frauds if we have a writing or writings that satisfies the statute. And what do we need this writing to do? It doesn't have to contain all the terms of the contract, but it must indicate the subject matter, the indicia of the contract, and what we are going to call essential terms. And going back to that concept of essential terms, price, subject matter, quantity are usually going to be essential terms under common law. And you may note that any writing would suffice. It doesn't have to be written with memorandum on the top. It just has to meet these features of being signed by the party to be charged, signed by the party to be charged, reasonably identifies the subject matter, is sufficient to indicate a contract was formed, not necessarily all the terms of the contract, and states with reasonable certainty the essential terms. And we saw in Sterling v. Taylor, we did not meet that standard because in Sterling v. Taylor, the signed writing had two different ways to calculate price term. One was a stated absolute price. One was a formula to calculate the price. The two did not add up, and so that you could read this one document and on its face, you could come to two different conclusions about what price was. As a result, this writing did not evidence that they had an agreement on price because there were two different ways to calculate the price. We also had the case of Howard Cole, which was a UCC case, and it shows in some ways that even sophisticated people cannot necessarily contract properly. And we have, again, the same issue here, where we do not produce a contract because the parties have evidence that they dickered about terms, but there is no signed writing signed by the party to be charged which has final terms. We do have evidence that there was negotiations, but the evidence presented of final terms are only signed by the party seeking enforcement, not the party to be charged. And so it's a reminder that the writing has to be signed by the party to be charged. And our final topic then is, when can we integrate several writings? We can, in some cases, integrate several writings and understand that they will comprise one writing for the sake of satisfying the statute of frauds. The restatement's pretty liberal. The restatement says that we can integrate the writings if they clearly relate to the same transaction. There is a more strict approach that the restatement does not take, and in the more strict approach, we have to have an actual integration, an actual reference. So in the case of Owens v. Hendricks, we have two different writings. The second writing does not reference the first one, and therefore the first writing does not come into the second one, which was signed by the party to be charged. This is the strict application, and we did not integrate the writings in Hendricks because we took a stricter application than you would find in the restatement. Crabtree versus Elizabeth Arden, however, followed the restatement more closely and did integrate the writings where a contract for employment clearly integrated these various different payroll cards, which had to do with the term of employment and the amount the individual would be paid. And so we see here that the restatement has taken a more liberal approach. And so then, to summarize statute of frauds, the statute of frauds, we first look at if we're in a covered category, think of MYLEGS, but in your jurisdiction, look to what statutes are actually on the books, then look for an exception to those provisions. Promissory estoppel applies to all of them, but the merchant exception and the part performance exception and the other UCC exceptions only apply to sales of good. Part performance under common law, section 129, definitely applies to land, might apply to marriage, doesn't apply to one-year contracts, and so you have to find the exception that fits for that basis. And so that's contract formation. Contract formation requires offer, acceptance, consideration, or an alternative thereto, and no exceptions to the statute of frauds. And so with that, I will say thank you.